Hi, everybody. Welcome, welcome, welcome. Shout out to everybody in the chat. Lord have mercy, I'm not prepared. Let me put this down a little bit because my computer's like all the way up here. Welcome, everybody. Welcome, welcome. Shout out to everybody in the chat. Make sure you guys hit the like button. Hey, GMAT. Hey, Pika. Hey, Storm. How are you? Mercy, Miami. Anika. Shout out to you. Megan, welcome. Hold up. Let me make sure the mic is on. Hey, Jason, how are you? Who else is in the house? I just started. I don't even know if probably notifications did not go out. Very likely. Phoenix, is it Phoenix Girl 020? Welcome. Minds, y'all, how are you? Oh my goodness, you guys. Everybody come through because we have a filing that we have to talk about. Okay. So Ghislaine Maxwell's attorneys have responded to the requests for the unredacted. If you guys remember, let's go back a little bit because I know I'm getting ahead of myself. If you guys remember, the judge had initially denied Pam Bondi's request to unredact some documents that a lot of us probably feel like at this point, what's the point? Because they're not going to give us anything that people are asking for, just so people are aware. Well, the judge had denied that request and said you haven't contacted victims, you haven't even contacted Ghislaine Maxwell. Ghislaine Maxwell filed a motion basically, and we're gonna read it. I haven't read it yet. And then I woke up to some news that the Clintons have been subpoenaed, and other possible elites out there have been subpoenaed. Yeah. I don't like this drink, but we're going to have to deal. You're not getting your notifications, probably because I just started. Put a 1 in the chat if you actually got notified via YouTube. Maybe that should be a survey question. Let me know, because like I tell you guys, this is the kind of stuff they like to suppress. Put a 1 in the chat if you have been notified by the YouTube. The YouTube monster. Nurse Janice, did you renew your membership? Shout out to you, Nurse Janice. See, Cricket Cinema said 1. Everybody said 1. Nurse Janice. And you upgraded your membership. Shout out to you. Thank you, love, for supporting the channel. Thank you. So you guys actually got notified? That is such a cute avatar, by the way. Lolly B, welcome. Okay, so we're gonna talk about this mess because it is a mess. Okay. So why don't we start here, and then we're going to run over to the Clintons. Apparently, the Clintons have been subpoenaed, and others. We're going to talk about that. But let's talk about this filing right here that was submitted by Ghislaine's attorney. I think his name is David Marcus. So Marcus Moss, PLLC. That's the agency, okay? PLLC. Okay, so we got to get started. All right. Oh my goodness. Nurse Janice, thank you so much for being a 7-month member. Shout out to you. You're doing great. Of course, I upgraded. Thank you, my love. Shout out to you. Oh my goodness. Shout out to the beautiful people that support the channel. Thank you guys. Okay, let's get it together. We're not even going to do an intro. So Ghislaine Maxwell responds in opposition. She's opposing to government's motion to unseal grand jury transcripts. What does this mean? I don't know. And now I'm kind of wondering. Although the government did not oppose allowing the defense to review the grand jury material to assess whether to object to its release, the court denied that request. As a result, Ghislaine Maxwell has not seen the material and cannot take an informed position. Given that she is actively litigating her case and does not know what is in the grand jury record, she has no choice but to respectfully oppose the government's motion to unseal. She's opposing. She doesn't want these documents out. She doesn't know what's in them. That's her position. Okay, already off the bat, letting us know she don't want nothing to do with it because she doesn't know what's in it. Let me know what you guys think in the comments. Do you think it's odd? Wasn't she saying she would speak? She had to put her demands out there. She said, listen, I'll talk, but I got to put my demands. Watch the side eye and rabbit today. Yeah, there's going to be a lot of side eyes. There really are. Yeah, so there's that. Sorry, I had to take a drink. Who does she think she is? Well, I guess that's the question. Who does she think she is? Because keep in mind that there's a lot going on. Are you discussing Diddy as well? I might if I have time, Daphne. I know there's something going on with Diddy too. I thought we were done, but we talked about Diddy yesterday too. So we might, just depending on how we end here, and then I'll fix my thumbnail. It just depends. Not even new inmates want her there. That's right. We did talk about that. Okay, let's get it together. Introduction. Jeffrey Epstein is dead. Maxwell is not. Whatever interest the public may have in Epstein, that interest cannot justify a broad intrusion into grand jury secrecy in a case where the defendant is alive. Her legal options are viable, and her due process rights remain. Well, damn. They just won the argument right there, but okay. When Epstein died, prosecutors from the Southern District of New York pivoted and made Maxwell the face of his crimes. She became the scapegoat, the only person the government could put on trial. She was convicted in a media firestorm of false reporting and mischaracterizations of evidence. Now, with her case pending before the Supreme Court, the government seeks to unseal untested hearsay latent grand jury transcripts, which contain statements presented in secret and never challenged by the adversarial process. Maxwell has never been allowed to review those transcripts, even though the government did not oppose her recent request to do so. She is now a victim. Anika, don't you forget, Maxwell is the victim now. We've changed the narrative, okay? She didn't do it. She wasn't there. She didn't even know. She had no idea. Let's keep going. The government seeks to unseal the grand jury transcripts, citing historical interest, without regard for how that release will affect Maxwell's privacy interests, her pending petition, and any future litigations. The government's memorandum cloaks itself in the Craig, but that case emphasized that disclosure requires the most careful judgment, and that the public's curiosity in a defendant's secret conduct at a grand jury hearing cannot eclipse the right the defendant has to secrecy and overwhelm his objection to public discourse. Because this is an ongoing litigation in a criminal case involving a living defendant with existing legal remedies, the government's motion should be denied. Okay, this is David Marcus arguing why they should be denying it. Yes, it's a different take, right? What do y'all think so far? I don't know. It's a lot of carrots that are being dangled in front of us. I'm just saying, okay? The government fails to establish special circumstances warranting disclosure of grand jury material in an ongoing case. There is a tradition in the United States that is older than the nation itself. The grand jury proceedings shall remain secret. Okay, and they're quoting the Henry Craig case. The tradition of secrecy is it's a federal rule of criminal procedure. The rule of secrecy is not without exception. However, the Rule 63E lists several exceptions. The Second Circuit has additionally recognized that there are certain special circumstances in which release of grand jury records is appropriate, even outside of the boundaries of the rules. In Craig, and importantly, the discretion of the trial court in deciding whether to make public the ordinarily secret proceedings of a grand jury investigation is one of the broadest and most sensitive exercises of careful judgment that a trial judge can make. And Henry Craig involves a petition by a doctoral candidate to unseal the nearly 50-year-old grand jury testimony of a high-ranking government employee, Harry Dexter White, based on historical interest in the White House suspect role as a communist spy. The court in Henry Craig denied the petition to unseal. On appeal, the Second Circuit affirmed the trial court denial of petition, finding that the court did not abuse its discretion when it found that sufficiently exceptional circumstances did not exist to warrant disclosure. In affirming the lower court's denial of a motion to unseal, the Second Circuit acknowledged historical interest as a potential basis for disclosure and offered a non exhaustive list of factors that a trial court might consider when confronted with a ruling on a motion to unseal. Those factors include, but are not limited to, the identity of the parties seeking disclosure, whether the defendant to the grand jury proceedings or the government opposes the disclosure, why disclosure is being sought in the particular case, what specific information is being sought for disclosure, how long the grand jury proceeding took place, the current status of principals of the grand jury proceeding, and that of their families, the extent to which the desired material either permissibly or impermissibly has been previously made public, whether witnesses to the grand jury proceedings who might be affected by disclosures are still alive, and the additional need for maintaining secrecy in a particular case in question. We did read this just so people are aware that this is just something that they pulled from cases, okay? Let's keep going. That was a heavy read. In Henry Craig, the court noted that all these factors and their precise significance must be evaluated in the context of a specific case. The timing of a request to unseal is one of the most crucial elements to be considered by the district court. In Henry Craig, here, the grand jury convened just 5 days ago, not decades ago. This is not a case where the passage of time erodes many of the justifications for continued secrecy, nor is it the case whether time has brought about the death of the principal parties involved in the investigation as well as that of their immediate families. Epstein may be dead, but Maxwell is alive and litigating her case. Okay, so basically saying like people have to consider Maxwell's position as well, because even though Epstein's gone, she's a defendant on that case, and therefore, she's also trying to litigate her side of the case. Okay, let's keep going. Maxwell's petition for a writ of this word. Remember, we were like, how do we say this word? I forgot how to say it. Certiorari. Hold up, y'all. Certiorari. Ooh, wee. Hold up. Sorry, y'all. The music. YouTube hates you. Don't worry. Notifications aren't going out. You can't pronounce. Well, we learned it, so I'm trying to say it correctly. Maxwell petition for a writ of certiorari is pending before the Supreme Court. She's preparing a habeas petition. Okay. We read this. Disclosure of grand jury material at this stage risks irreparable tainting the legal process by injecting sealed testimony into the public debate while judicial review is ongoing. The reputational harm from releasing incomplete, potentially misleading grand jury testimony untested by cross-examination would be severe and irrevocable. Those allegations, if released in raw, untested form, would inevitably influence any legal proceeding should Maxwell succeed in her post-conviction litigation. The government's proposal to redact victim identifying information does not mitigate this harm. The substance of the allegations, not the names, creates the prejudice. Public curiosity is insufficient. When Maxwell's legal and reputational interests are at stake, these factors weigh heavily in favor of preserving the secrecy of the grand jury material. The attorney doesn't want, if I was Maxwell's attorney, I would be concerned about anything. If my client has a potential to, be heard, all this other stuff, yeah, I have a problem with, you got these transcripts and they haven't been tested, they haven't been heard. I'd have a problem with people wanting this information to be unsealed. But my thing is that what we've heard so far about these documents it's about the investigation, and the witnesses are federal agents or government employees, right? So nothing like testimony from other folks that were in close relation to Epstein. Literally. You said if Ghislaine is parting free Luigi, says Mandy. Ooh, What do y'all think about that? Let's keep going, okay? Although the government's memorandum sets forth that certain aspects and subject matters of the transcript became public during Maxwell's trial, Maxwell has never had an opportunity to review the entirety of the grand jury material in her case. The government provided a list to the court under seal of the witnesses whose accounts were conveyed in the grand jury and a correspondence list noting which witnesses testified at trial. The list has not been disclosed to us. The government's memorandum, however, acknowledges that the law enforcement witnesses who testified before the grand jury are alive and remain active at the FBI and NYPD, respectively. The government's memorandum also disclosed that many of the complaining witnesses who formed the subject matter of the grand jury witness testimony are also alive. Okay, this factor likewise counsels against disclosure of grand jury transcripts, given the need to protect both active law enforcement personnel and alleged victims. They're all alive, but what are we getting if they release this information? That is the question. What do you guys think in the chat? Literally, you said if we got to pardon, damn, you guys are going to pardon everybody? Pardon Jonathan Oddie. Pardon them all. Pardon them all. What else? What else do we have? Who else are we going to pardon? Okay? That's the question. Y'all are going in these comments. Make sure you guys are hitting that like button, please, and thank you. This is a nasty energy drink, and I'm drinking it because I don't have any other choice. Sorry, y'all. I just thought I'd let you know. There is no precedent supporting release of grand jury transcripts in a pending case like this one. None of the cases cited by the government justify disclosure here. In a repetition of National Security Archive involve a decades-old grand jury proceeding against Julius and Ethel Rosenberg related to charges of conspiracy to commit espionage by providing information about the atomic bomb to Soviet agents. They're citing cases. In 1951, the Rosenbergs were tried, convicted, and sentenced to death. They were executed in 1953. In 2015, upon a motion by a nonprofit institution and others, Judge Hellerstein granted a petition to unseal grand jury testimony of David Greenglass, Ethel Rosenberg's brother. In granting the petition to unseal Greenglass's grand jury testimony, the court observed that in the 65 years that had passed since Rosenberg's trial, many believed that Ethel Rosenberg was innocent and had been framed by Greenglass. It took them 65 years to figure that shit out. It took them 5 years. Excuse me, 65 years. See what I'm saying? That's what makes me so mad, that it's like, we got 65 years. This is 65 years. And this crime was just, within the last, I don't know, 20 years, 10 years, 15, put a date on it. It took them, and then they found out, oh, no, sorry, it was a mistake. The brother lied. As a result, and only after Greenglass had passed away, the court concluded that Greenglass grand jury testimony had been released since it provided information in a case of historical interest to the public. But yeah, it took them 65 years. Holding that request records are critical pieces of an important moment in our nation's history, and the time for the public to guess what they contain should end. It is noteworthy that Judge Hellerstein refused to unseal the transcripts while Greenglass was alive, finding that Greenglass' interest in preserving the secrecy of his grand jury testimony was sufficient to prevent its unsealing during his life, despite the public interest in this case. Damn. In a repetition of American Historical Association involving a similar request by historical associates in 1998 to unseal transcripts of two special grand juries convened from 1947 to 1950 pertaining to the espionage investigation of Alger Hiss. Hiss, a former high-ranking State Department official, was convicted of committing perjury in responding to allegations that he was a Soviet spy. Hiss maintained his innocence until his death and publicly suggested that his prosecution was a political hit job by Richard Nixon to mobilize public opposition in communism. Like, we've never seen Okay, let me stop. In granting the request to unseal the 55-year-old grand jury material, the court noted the significant passage of time along with the facts that most of the relevant witnesses, including his, had died. Y'all see that? 55 years, 65 years. I don't know. Like, people pass away, you know? Let's keep going, guys. Let's keep going. The court ultimately ruled that the great historical importance of his case outweighed the minimal interest in preserving secrecy, noting that the alleged Soviet espionage against the United States was controversial and historical significant issues in domestic politics during the 1940s and 1950s and to present day. Disclosure is being sought in this case due to immense public interest in Jeffrey Epstein and Ghislaine Maxwell cases, along with the public interest in the government's handling of those investigations and prosecutions. The public interest identified by the government, while understandable, is insufficient to warrant disclosure of grand jury material at the time. The government frames this interest as historical, yet it is nothing more than a widespread and intense public curiosity about an ongoing criminal case. Neither an in-read petition of National Security Archives or in-read petition of American Historical Associations support the conclusion that Maxwell grand jury material should be released. Each of those cases involved testimony dating back at least 5 decades, along with grand jury testimony related to defendants and witnesses who were deceased. Henri Baggy is equally unavailing. That case involved the unsealing of grand jury testimony of the U.S. Congressman Mario Baggi, who had been indicted, who had waived any protection to secrecy by seeking complete disclosure in a form of a motion requesting disclosure of his own testimony for its own sake. The government and Henri E. Baggi moved to unseal Baggi's grand testimony only after Baggi petitioned a 3-judge panel in the Southern District of New York to examine his grand jury testimony and publicly report whether he had invoked any constitutional privileges related to his personal finances or assets. The Second Circuit affirmed the district court ordered directing the public disclosure of Baggi's testimony based solely on his waiver, finding that no matter how much or how legitimate, the public may not want to know whether a candidate for high public office has invoked the privilege against self-incrimination before a grand jury or has lied about having done so. That interest must generally yield to the largest one of the preserving the rule of law embodied in Rule 6E of Federal Rules of Criminal Procedure. But that is not this case. Maxwell, unlike Baggi, has preserved a right to grand jury secrecy and vigorously opposes the disclosure of grand jury material. To me, it sounds like they don't want anything out that could taint the public perception or the public anything of anything. Okay. It's a lot of craziness when it comes to this. Let's keep going. Okay. Hold up. We're almost done. Lastly, the Florida case, the government cites Florida Holdings versus Dave Ehrenberg has no it has no value in this jurisdiction and involves a civil suit under Florida public records law, not federal grand jury material protected under Rule 6E. Okay. It further goes. There is no precedence for unsealing grand jury transcripts in an ongoing matter like Maxwell's case. Accordingly, the government's motion should be denied. Conclusion: the government's motion to unseal the grand jury material in this matter should be denied. And that is coming straight from the desk of David Marcus. They don't want nothing. Unseal. Because it could mess up their deal, right? Could it? Sometimes public perception. Let me stop right here. This drink is bugging me. I need some water. Give me 1 second, y'all. You know how when you drink a really bad drink, it messes with your taste buds? That's how I feel about this drink that I'm drinking. So that's why I'm like, oh my God, I cannot. I cannot. Just messes with me. Okay, so I think that there's probably more, clearly they don't want any grand jury transcripts released. And this is from Ghislaine's side of the coin. Now, today is August 5th, August 5th, and they were supposed to actually be receiving letters, okay? Letters from victims. They've already received, I think, two specifically of anonymous victims about the handling of the Epstein files. And so they have their say about how they want to see things, just so people are aware about what is happening here in this situation, okay? Okay. Ooh, let me close that down. Let's talk about this little situation right here. The Clintons. U.S. House panel subpoenas Bill and Hillary Clinton for Epstein testimony. Lord have mercy. Are we surprised? It shouldn't be the only ones subpoenaed. They shouldn't be the only ones. It should be Donald Trump. It should be all the people that are around, everybody else that we don't know, like Mr. Bill Gates and anybody else, the Rothschilds and whoever the hell y'all put the name in there. Okay? It should be everybody else. I am not doing promo for that. Okay. So subpoena them all of them. Subpoena all of them. Elite subpoena. Period. That's it. Okay? Everybody. Okay? Yeah, they're intentionally cherry picking who they're going to subpoena and then deciding who is a private citizen around this time. No, subpoena all of them. Okay? Okay, stop. All right. Sorry, that thing keeps popping up. House Oversight Committee also issued subpoena to several former attorneys, attorney generals, and FBI directors. Lord have mercy. Okay, so the House Oversight Committee on Tuesday subpoenas to Bill and Hillary Clinton, as well as several former attorney generals and directors of the FBI, demanding testimony related to the horrific crimes perpetrated by Epstein. The investigative committee Republican chair James Comer sent the subpoenas in a response to a two-motion lawmaker approved on a bipartisan basis last month. Give me 1 second, y'all. One second, y'all. Sorry. Uh Margaret Losa Babbitt, thank you so much for becoming a member. Shout out to you, love. Thank you for supporting the channel. Sorry, y'all. I had to, I gotta multitask. I don't know about a lie detector test because those aren't admissible in some courts. So I don't know how much attention I would pay for that, but I'm just letting you know. But thank you so much for those that have become members and supported the channel today. Thank you guys, because this is the stuff, like I said, and unless you got a big following, this is the kind of stuff they like to suppress. So I'm trying my best to kind of put as much information out there. Okay, it further goes. The investigative committee. Oh, just put it on the floor. Thank you. The investigative committee, Republican Chair James Comer, sent the subpoena in response to two motions lawmakers approved on a bipartisan basis last month, as Congress navigated outrage among Donald Trump's supporter over the Justice Department's announcement that it would not release further details about Epstein, a disgrace. We know who died, who was awaiting trial on ST charges. The subpoenas raised the possibility that more details will become public about Trump's relationship with Epstein, which stretched for years but appeared to have petered out by time Epstein was convicted of abusing girls in 2008. Last month, the Wall Street Journal reported on the existence of sexually suggested sketches and lewd letters Trump sent to Epstein on his 50th birthday in 2003. Okay. It further goes, the president and his allies have long flirted with conspiracy theories around Epstein's death in federal custody, but the Justice Department upended those by concluding that he died by S, and long rumored lists of clients did not exist. So if they didn't exist, think about it, y'all. The only reason why this probe is happening the way that it's happened is because people have told Trump, we're not accepting this BS, Trump. You got to come with it. Okay. I mean, the speculation with the Clintons has been there. A lot of us don't. I don't like the Clintons. None of us like the Clintons, right? I could probably put a poll, and a lot of you guys would say we don't like the Clintons. We agree, and there's a lot of them. But I also don't like Trump, and I also don't like anybody else that is in this little elite circle, the elites at the cafeteria table. I don't like any of these guys. I don't, and I don't believe for 1 second that none of these guys have anything to do with anything. Okay. It is what it is. It is what it is. Let's see. Let's keep going. To me, they're all cut from the same cloth. Okay. The president and his allies have long flirted with that. We read this shortly before the House lawmakers left Washington, D.C. for Congress in August recess. The Republican Congressman Scott Perry won an oversight subcommittee approval to compel the deposition from the Clintons and the former top federal law enforcement officials in a bid to reveal more about Epstein's activities. Democratic Congresswoman Summer Lee also successfully published a motion to subpoena Justice Department files related to the case. Good. So things are going to get looked into, and I'm here for it. I am so here for it. Okay. Exactly. Nobody really knows what the list looks like, but I feel like the people that are, that one saying that hit dog will holler. There's a lot of dogs that are hollering at the White House. Okay. There's a lot of dogs that are hollering. And then the doggies that are next to the dogs are hollering too. Everybody's hollering. And we could hear it. At least if you're paying attention, you could hear the holler in different ways, but you could hear, you're like, damn, you're hollering a lot. Really? Really, really, really? Okay. You said even if an ex-president is prosecuted, the current president will pardon. There you go. There's that. You said, I know my dogs can't sleep because they're hollering. You said you're only like, what does that have to do with anything, Aduko? Whatever, Aduko. That was funny you said that, though. Shout out to you. I don't know how one has to relate to the other, but okay. Let's keep going. Y'all are funny in the comments. Okay, so in the letter, Bill Clinton and Comer noted that former president had flown 4 times on Epstein's private jet and repeated an allegation that he had pressured Vanity Fair to not publish trafficking claims regarding Epstein. The chair further says that Clinton was allegedly close with Maxwell, the British socialite, serving 20-year sentence after being convicted of trafficking charges related to Epstein. Given your past relationship with Epstein and Ms. Maxwell, the committee believes that you have information regarding their activities that is relevant to the committee's investigation. Yeah, I would agree. In this letter to Hillary Clinton, Comer draws a more tenuous connection, writing, your family appears to have had a close relationship with both Epstein and his co-conspirator Maxwell. In addition to the details about them, Comer noted that Clinton may have knowledge of efforts by the federal government to combat international trafficking operations of the type ran by Mr. Epstein. Comer set Bill Clinton's deposition date as October the 14th. Okay, so that's like in 2 months or so. And Hillary's as of October 9th. Okay, 9th and the 14th. Put that in your calendars. Put it in your Palm Pilots. Put it in your little planners. We got depositions apparently tentatively scheduled for October the 9th and the 14th for the Clintons. Okay? Did you put it in your Palm Pilot? Belen, did you put it? Did y'all? Okay. Just want to make sure everybody put it in their Palm Pilots, okay? Hold up. Now, what is going on? Let me know what y'all think in the comments. It further goes, okay? Let's see. So others who received subpoenas were given dates ranging from mid-August through early October, while the U.S. Attorney General Pam Bondi has until the 19th of August to release documents related to the case. In addition to the subpoenas, Republican Congressman Thomas Massie and Democrat Ro Khanna are collecting signatures for a discharge petition to force a vote on legislation compelling release of Epstein files. A vote is not expected to happen until the House returns from recess in early September. That is the longest freaking recess, but okay. Trump has authorized the Justice Department to request release of transcripts from the federal grand juries that indicted Epstein and Maxwell, while last week, Attorney General Tom Blanche interviewed Maxwell in Florida in that White House, said was a bit to uncover new details about the case. And there is nothing weird about the fact that Todd Blanche was a former attorney of Trump, and now Todd Blanche is having secret meetings or had secret meetings with Maxwell. All of this shit should stop being a secret and it needs to be public, period. Okay? I have spoken, and it is what it is. That's what I think. You said the Supreme Court made Trump above the law, so really he can do anything he wants with zero consequences. That's what it looks like, my friend. It just makes you wonder. You guys got to put those dates down. I don't know why y'all laughing. Palm Pilot sounds like dirty to me, but maybe I'm just lonely. Don't y'all remember the Palm Pilots? I was like, whatever happened to the Palm Pilots? Hold up now, my friends. My friends. Now, I didn't want to let you go because somebody asked about Diddy. Let's see if we have, I know we have Diddy documents. Give me 1 second. See if I can pull those. So we did the bail denial. Now, shout out to, this is the redaction order, and this might be, I might have to re-edit this video because I didn't have time. Did I read this already? Okay, that was the judge's opinion. That's not what I want. Why did they, so if you guys remember, let me stop real quick because I know I'm like all over the place, and there's a reason. My sitter is in and out today. My sitter will be back tomorrow full time, but I'm going to see if I can find this. There's a reason why there was a lot of redactions. We're going to the Diddy real quick. Shout out to Diddy Docket. Diddy Docket posted this for yesterday. Remember when the judge basically said, hey, why did you guys, the judge was asking the prosecution, why are you guys redacting information? There's a huge redaction. There's a huge redaction in the defense side too. There's like redactions everywhere. Let's go back to the Diddy trial. Okay. Jump over to the Diddy trial. All right. So we gonna get into this real quick while I have the time to do it. I'm on a time crunch right now. This is not what I want. This is not what I want. Okay, here it is. Prosecutors say their redactions are in accordance with October 7, 2025 protective orders in the case, and add that despite the use of pseudonyms, redacted information could lead to victims or witnesses' identification. So the judge has said, why are you guys redacting things? What's going on? The government writes, the government respectfully submits this letter in response to the court order dated August 1st, 2025, directing the government to explain the need for a redaction in its July 31st, 2025 letter opposing the defendant's motion for bail. On the July 31st letter, given the use of pseudonyms in the unredacted version of the letter, for the reasons stated below, the government submits that the redacted portion of its opposition motion should be filed under seal. They list the legal standard out of that. Okay. I'm going to skip over that. I want to go to the discussion, which is where a lot of this is highlighted. The government has proposed minimal redactions to the July 31st letter, which only covers statement by witnesses and victims to the government and law enforcement were not disclosed at trial. As the initial matter, the proposed redactions comport with the protective orders under by the court case in this case, which governs all 3,500 materials. There was 3,500 pieces of evidence in the Diddy trial. Keep that in mind, including the instant statement by victims and witnesses. While the parties have discussed the content of some 3,500 material on the record, the parties have consistently redacted statements from 3,500 materials from filings throughout the case. Moreover, the government proposes redactions to the July 31st letter, which total approximately 4 sentences in the government's 11-page motion, carefully balance the interests of the public in disclosure with the need to protect the privacy interests of witnesses and victims who voluntarily cooperate with the government, particularly on topics of sensitive nature. Although the names of relevant persons are, what is it? how do you say that? Anonymize? Lord have mercy, they're making up words. Anonymize. Thank you, Google. Anonymize. That's the word. They're not making up words. I just don't know how to pronounce them. Of relevant persons are anonymized. The redacted information, which includes approximate dates as well as other pertinent details, could nonetheless lead to the identification of victims and witnesses. Further, the redacted information describes the statements of victims to law enforcement and other incidences of highly sensitive nature. The interest in protecting these victims' privacy, therefore, outweighs any public interest in disclosure. Da 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 da. Sincerely, Jay Clayton and the rest of the attorneys. Okay, so that was because the court requested, why are you guys redacting information? So this is as it pertains to Diddy. Let me know what y'all think in the comments. Did you, Amy? Did you? Okay, I have something bookmarked, and I didn't know about this. I didn't know that Putin had a secret daughter. I know that I'm just kind of throwing this out here, but I saw something, and the girl's in hiding. Is that correct? See, I didn't know this. Sorry, you said Putin, and I had to put this out here. Destroyed my life. Putin's alleged secret daughter resurfaces online. It's an alleged secret daughter? Have y'all ever seen this? Mercy Miami, you seem to know everything, girl. Have you seen this then? I didn't know about this. What he do to his own blood? I didn't know this. That energy drink is gross, but I gotta drink it. Blah. Sorry. Who are they? She's very private. I'll have to do a video on this. You think you heard? Is it his daughter? I'm scared to talk about this guy though, because they be taking channels down and stuff like that. I mean, come on, my man's been known for clapping cheeks. Wait, what? Lord have mercy. Job, I think you were in my comments. I'm gonna be doing a video on that, by the way. I don't know if you saw my community wall post. I'm gonna be doing a video on that. I have to do a video on that. We're gonna talk about that. What's her name? Brett Cooper, that lady. Yeah, we're gonna be talking about that. I promise. Keep an eye out. It needs to be a pre-recorded though. Wait, so Putin claps cheeks? What are you guys talking about? What I didn't say. It's no, Tea Maker. You getting me in trouble? Where are you at, Tea Maker? I mean, come on, my man's been known for clapping cheeks. You said that, Tea Maker. I can't with y'all. Y'all are too much in my chat. What you mean? This is weird. It's a weird situation. What, he has a daughter? Is this I don't know. Does he have a daughter? Apparently, this is what I saw. And the reason, and I know this source because this is the same source that Dialogue Pakistan. This is the first time I've heard this, but I didn't know the guy had a daughter and then he was trying to keep her secret. I mean, hey, he does kind of look like him. Has he acknowledged her, or does she speak? Is it kind of like an Elon situation where you know how Elon has a child that I think she identifies as trans, and Elon's like doesn't want to give any kind of clout or recognition, or not even clout, that's the wrong word, any kind of recognition to this child because of, yeah, it's a bit risky. Well, I didn't know. I heard about this. Somebody mentioned Putin. That's why I brought it up. I didn't say that. Tea Maker, you're going to get me in trouble. Tea Maker's the one that said it. Doesn't he have like 5 wives? Who? Elon or Putin? I don't know too much about Putin. I really don't. That's the question. If you're a public servant, how do you expect privacy? You can't expect privacy as a public servant. Hell, even when I worked, in government for 10 plus years, people knew your salary, people knew your information, they knew how much you made. It's public information. This is why they tell you when you're working in government, you live in a glass house. People can see everything that you're doing. Yeah, Elon has a bunch of kids. He does. She lives in Paris under a pseudonym. Wow, that's crazy. You said Tea Maker, I know, but why'd you say he was clapping cheeks? Like, I didn't expect Tea Maker. I never expect you to say that. Shout out to Tea Maker. Putin's been playing the game well. I mean, his wife didn't see him for years, even when she really. Wow. Does public service rules apply to dictators? No. I mean, but the public service in the U.S., right, is different than the ones in different countries. So keep that in mind, right? Some rules don't, their rules don't apply to us, right? And our rules don't apply to them. But if you are a public servant in the in this country, you are living in a glass, you're expected to have everything reviewed, even though people want to keep shit private. Like, you are a public persona, people can look up your information and find out things about you. It's easy to find out things about you. So, if you're working in government, if you're an elected official as well, right? But yeah, the public service in the US is about to change. It wouldn't surprise me, Mandy. It wouldn't, you know? Look at, so let me, no, Vicky's like, let me stir up the pot, rabbit. Go ahead, Vicky. So let's stir up the pot. Isn't Miss Maxwell a US citizen? Isn't she a citizen of the UK? Why hasn't she been sent to alligator Alcatraz and deported? We said this like 2 days ago. Why hasn't she been sent to, like, she's been sent to Club Fed? She should have been sent to Alligator Alcatraz, where they have all the people that need to be deported. It's just inconsistent, right? None of this, it just doesn't apply. It's inconsistent. I brought this up yesterday. Some of you guys got mad at me in the comments too. Are like, how can you compare? Like, let's talk about it. You have a notorious woman Momo, okay? A woman Momo, you know what I mean? 1,000 victims. We're doing deals with the devil. The lady goes from going to this prison to now stepping down to a facility that she could just walk out from. She should be going to Alligator Alcatraz. That's where she should be at. And she's one of the most dangerous women momos out there. We don't even know the magnitude of the victims. There's an inconsistency, but we want to talk about Diddy's, his bail package and what is and or what isn't. Y'all, I'm telling you, it just doesn't make sense. She has dual citizenship with the US and France. She's not a naturalized citizen, nor was she born in Sydney. Yeah, so there's no reason why she should be having any kind of amenities. You have people that are waiting to get, that are waiting in lines, waiting years for citizenships. People don't even realize that. So yeah, it's stupid, but nobody's calling into question that, right? Nobody's saying anything. She's not. She's getting preferential treatment. That's absolutely right. You had a couple of those guys that were wrongfully deported too. Like, nobody's talking about that. But y'all want to give really nice treatment to Maxwell? It's crazy to me. Y'all let me know what you guys think in the comments. Just my little humble opinion. She should be deported. she should be in a, well, I mean, not even deported, but at least held where she's at. She's considered, and she needs to be in Alcatraz, that Alligator Alcatraz. She's a felon. Okay, she's on a step down Club Fed arena where reality TV's, and what is it, Elizabeth Holmes, that's where she's at. This is so inconsistent. We have an inconsistent system. Okay, we do. And there's inconsistencies even with Diddy. Diddy's victims aren't children. Keep that in mind. His victims are less than You probably, at least, let me be very clear. In the criminal case, okay, he doesn't have a double digit in victims. All right. So there is some inconsistencies with the way in which this woman is a notorious Momo, child Momo, participated and engaged in it. There's an inconsistency in the way in which we're treating this situation. And then here we have Diddy. We can never keep this shit the same. We just can't. Weird. Or maybe it's not. Maybe it's meant to be that way. I agree. I agree. Mm. She's in. I cannot believe it. I don't know. I don't know, man. It's a genuine question. Wonder if she still has money or her net worth is now, and is her power, knowledge, or money for both. Yeah, it's getting a little bit crazy, y'all. I'm just letting y'all. I'm just calling it out, even though some people don't like me doing that, but I got to. I got to. Another video, guys, that this is the video that I'm talking about. We're gonna talk about this little shit show right here. I hope you guys watch. I haven't recorded it yet. I'm not familiar. Somebody in the chat said, Rabbit, you need to review this. And it kind of, I watched it and I said, oh shit. This is Brett Cooper. This girl right here, I think she worked for like The Wire or something like that. And it's some shit that she's saying, okay? So we're gonna talk about that. It's gonna be a pre-recorded video. Again, involving she's making it's the weird comparisons that she's making, but involving Britney Spears, Trump, and mental health. Okay, keep an eye out for that. Okay, keep an eye out for that video. I gotta record it. And I'm working on my notes on that one. Let me know what you guys think in the comments of all these topics that we just talked about. Make sure you guys are hitting the like button, please, and thank you. Support, share the channel. Thank you. I would really appreciate it. And I will see you guys later on. I'll probably be live later. Okay. Yeah. Bye, guys. Bye, bye, bye.